Welcome to Business Talk with Meghan McNulty, the podcast that takes you behind the scenes of business success and reveals the strategies, insights, and stories that drive these professionals to thrive in the ever-evolving world of business. Whether you're an established entrepreneur, a seasoned business owner, or simply fascinated by the world of commerce, this podcast is your front row seat to learn from the best. Each episode, Meghan will bring you engaging interviews with professionals from diverse industries who will share their triumphs, lessons learned, and the insights they've gained along the way. Hi, Sean. Thanks for being here today. I would like to introduce you to my listeners. You're a probate and trust litigation attorney here in Southern California, and I believe also some other states. I'll let you tell us a little bit more about that. But I was hoping you could kind of briefly tell us how you got into litigation and the probate and trust world.
Yeah, sure thing. And thank you for having me, and hi to all of your viewers. So I've been practicing since 2002. I've been a litigator my entire career. I've done all kinds of different litigation, from maritime to securities, to general civil lit, and even in some instances, some aerospace manufacturing type litigation. My partner and I started this firm, it'll be 10 years next year. And he had done some probate litigation before. So we had a smattering of cases, and it very quickly became the primary area that we were practicing in. And the demand for us was growing exponentially. So we decided to focus our efforts on this space. We've been trust and estates litigators and ever since.
Can you tell us a little bit about what the difference between probate litigation would be and trust litigation, or is it the same thing for some that might not know?
Yeah, in general, it's the same thing. When we talk about probate litigation, generally what we're talking about is litigation that involves a probated estate. So that would be an estate that has a will, or if someone died without an estate plan. Those matters and the distribution of assets go through a probate process. Trust litigation involves a trust, and there are very similar disputes, and it's the same court. The probate courts in California have jurisdiction over probate or will-related issues and trust disputes. So they're very similar. Some of the same things kind of come into play, but it's a difference really only in terms of how the estate plan was put together.
I see. Can you briefly tell us maybe about why a family would be contesting a trust? So they come to you and they say, look, I have this trust, my parents set up, and now my siblings are fighting. What's like the most common scenario?
Yeah, the most common fact patterns that we see really boil down to family dynamics.
Okay. And
it's the family dynamic that plays a huge role in a lot of this, in terms of blended families, especially second, third marriages, step parents, step children. That's a very, very common fact pattern. But the types of claims that are asserted are things like lack of capacity, saying that whoever created the trust or a will didn't have the requisite mental capacity to do it. Claims of undue influence, meaning that somebody pressured the person who passed away to make a change to their trust or estate plan in a way that that person didn't really want it to be done. Then we have, the ordinary claims of some kind of malfeasance by a trustee, either not managing the trust in the best interest of the beneficiaries or just outright stealing money from it. Those are probably the most common ones we see.
When clients come to you, do you go try to help them like avoid going to court first? What does that look like? Or basically when they come to your office, they're already going to be going to litigation over this trust?
Usually by the time someone has found us, there's a dispute enough that is at least worthy of engaging counsel. And it's certainly headed in the direction of court. We don't do any of the planning work. So by the time you come to RMO, there's a dispute. And we do work with our clients to work on trying to get something resolved. Because the litigation process is long, it's hard, it's emotionally tolling, and it's expensive. If somebody can get something done before pulling the trigger and getting something filed, that's terrific. And we're happy to help try to make that process happen. Sometimes you can't avoid it, and it doesn't mean that you can't still try to work to get it resolved. If you're up against a deadline, you have a statute of limitation that's about to expire, sometimes you don't have the luxury of trying to avoid going to court while you're trying to get it resolved. You have to go, and then you try to get it resolved.
How would you tell someone that's planning their estate right now and doing trust documents? What would be your best advice to avoid litigation in the future?
The best way to avoid litigation in the planning process is to be very careful with planning. Doing planning, especially on an estate that is, in any way complex. If there are business interest holdings, significant investment assets, lots of real estate, commercial real estate, engaging a good planner to ensure that that planner knows all of the ins and outs, including the family dynamic, making sure that whoever is putting the document together really has a firm understanding of where everything is, how people get along, and help that person draft a document that is less susceptible to litigation.
It's very important. So common issues in the trust dispute. So you mentioned families that are blended, which we have, maybe a family over here, mom and dad had kids together, then mom remarries, dad remarries. Now you've got like 3 sets of different kids in these families, and maybe, original dad set up the whole trust and has a lot of money. What do you think goes on? How do you guys resolve these? If, let's say, it goes into a trust dispute and there's a mediation, how do you resolve conflict between the families?
Well, sometimes it's not easy, and the emotions can run high. So a big part of the mediation process and getting something resolved, especially in a formal mediation, a lot of the hard work falls on the mediator. A lot of people want to be able to get their story off their chest, so they're going to need to vent and have their day, and have someone listen to them and understand what they're saying and empathize. The remedies that can be crafted in the settlement agreements, one of the things that I tell clients all the time is that, when you're in a settlement discussion, the remedies can be, very creative and almost unlimited. You can figure out ways to address problems in a mediation or a settlement that you are not going to be able to do in court. You're in control at the settlement level and the mediation level. At mediation, you can always say no. In settlement, you can say no. Once you go to trial, it's the judge that's going to make the call. So often it just boils down to money and dividing assets in a way that people are satisfied.
Do you think, I'm curious, do you think mediation is more expensive than court, or is it normally less?
Well, it's certainly less in terms of, doing it early.
Okay.
If you do it early, then, the litigation machine hasn't been running for as long. The downside of doing it early is you may not have all of the facts and information and discovery that you might want to have to make an informed decision. But even if you do it late and the litigation machine has been going like cuckoo for a year and a half, 2 years, it is still often a better outcome. A lot of mediators say that a successful mediation is one where the 2 parties walk away equally unhappy. And that might be true, but you're still in control. You still have the decision-making authority. Once you get to trial and you go all the way through trial, that decision-making authority is gone. It is in the hands of the judge. And
So you're giving some of your power if you go to court. So in these cases, how like liable is the trustee? So the trustee of the trust, once someone dies or whatnot, how liable are they in some of these disputes if the beneficiaries are fighting? Do they get sued often, the trustees of the trust?
Yeah, well, trustees, trustees get sued a lot. It's pretty rare for a trustee to get sued in the context of a dispute between beneficiaries over trust provisions.
Okay.
But trustees, can get themselves in trouble in terms of not really understanding what their obligations are. Trustees have fiduciary duties, which means they have to put the beneficiaries ahead of everything else in front of themselves. And they have to manage these trusts, and sometimes it's complicated in a way that is beneficial to the ultimate beneficiaries. And lay persons who come in and are named as a trustee in a trust can, not because they're bad people, but because it's complicated, can sometimes step in it and find themselves being sued for breach of trust or breach of fiduciary duty.
Fiduciary duty. What if I was a beneficiary of my parents' trust and I was upset with my sister who's trustee because she was not managing the properties my family left to me the way I saw fit? How could I get her removed?
Well, it's a petition to the court.
Okay.
If she doesn't agree to step down, it's a petition to the court to say that she was breaching her fiduciary obligations. In that hypothetical, it would be that she was not making trust property productive. That's one of the duties that a trustee has. And the way we generally approach those kinds of things is we ask for an immediate suspension as trustee, meaning that their authority is stopped. And then when you get to all the way to trial, then the trustees removed. A lot of times, the easy solve for that is if everyone agrees that we will just have a professional fiduciary come in. People who do this for a living rather than a lay person doing it.
Right.
And those people are bonded, and the courts like it when you do that. It makes things a lot simpler and gets things resolved faster.
What if, I have another question about trust litigation. So what if you have a case where you have first and second wife and kids from the first marriage, and it's in probate and we're waiting to distribute the funds, and the probate monitor, I guess, what would you call them? The in-place trustee to manage this situation, and then also the person to manage the stuff that's not in the trust. What if they're appointed by the court? So I forgot what you would call them. Probate.
That would be the administrator.
Okay, so it's someone that is deemed not part of the family, outside, the court appointed them, they're getting paid a fee to manage this whole situation, and they start taking forever, taking years to file everything. Is there any way to say hey, we want to fire those people because they're moving so slow and they're misusing our money, and et cetera, et cetera?
Yeah.
We're gonna have plenty left by the time this case is over.
Yeah. It's the same thing. It'd be like removing a trustee.
Okay.
You can get an administrator removed for the same reasons. The good thing on the probate side of things that you don't see as being a requirement of lay trustees is that when someone's appointed as an administrator, they're also required to post a bond.
Okay.
And that secures the estate and the beneficiaries of the estate from any damage they might cause.
So that gives them some protection there. Also, I guess, can you share some real life examples of trust disputes that went to court?
Yeah. I can give you one.
Okay.
It's one that I enjoyed trying. Took a case to trial. I think this was 2, maybe 3 years ago now. And in that case, my client had been the beneficiary of her aunt's trust for years. My client lived out of state, out of country, and it came to be that her aunt's neighbor became the full beneficiary of her aunt's trust. As we were going through the litigation process and discovery, We were turning over all the stones, and we found a letter that the neighbor had written to the homeowners association, where she was effectively saying that she was the aunt's caretaker.
Oh,
With the caretaker, there's a presumption of undue influence that then the beneficiary caretaker would have to prove that it was not the product of undue influence, rather than us having to prove that it was. By virtue of that letter, we were able to get an order from the court pre-trial that the burden shifted to the caretaker beneficiary, and she had carried the burden of proof to show that it was not undue influence. And so she had to try her case first.
wow.
With her case, and I believe it was over the course of 2-3 days. I didn't think that she met her burden and moved for entry of judgment, and it was granted.
Wow.
So
Okay.
those kinds of cases, and when it works out that way, it's kind of fun. You have the litigation, and you get a great result for somebody. It's pretty satisfying.
Yeah, it sounds good. What about, so you kind of mentioned caretakers. What is the latest, like, there's a lot of lawsuits regarding caretakers. Is there a reason for that? I noticed that lately, that these caretakers sometimes are suing the estates after. Do you do any of that kind of law litigation?
Well, we see things like that quite a bit. The interesting thing with caretakers is, in terms of them litigating against the estate, it's usually for unpaid wages. And so you can end up in labor and employment cases. At least that's what I'm familiar with.
Okay.
In probate, to assert a claim against an estate, one, the probate has to be open, and two, you have to submit what's called a creditor claim. And the creditor claim is governed by a very short limitation period, where you have a year from date of death to assert that claim. If you don't, the limitations period is gone. It doesn't matter how long the limitations period still had on it when the person died. If you don't follow that procedure very, very closely and carefully, you can end up being time barred. And, I've seen that quite a bit, with people coming to us well after the fact, a year and a half, 2 years later, and they say, we want to sue an estate for, a dead person's liability. We have to say, you blew it. It's too late. You can't do it.
Wow. Okay. Interesting. Well, another scenario I want to bring up is, what if you go to court and a judge says, okay, sorry, everybody, this trust is invalid. Like, the trust is no go. It's not, can't follow it. What happens then?
The court also has some pretty broad remedies that the court can fashion. So in some instances, you can see a court just striking a particular provision of a trust.
Okay.
In other cases, you can see the court making a modification to some of the language in the trust, especially if there's some kind of an ambiguity, or tossing the trust altogether. And it depends then what else had been in place before. So if it was a trust that had been modified, then you might revert back to the prior iteration of the trust rather than the modified version of the trust. If there were no other estate plans, then you could go back to a will. If there's no will either, then it could be deemed that the person died intestate. But one of the remedies is, particularly if you find that someone has unduly influenced, you can also have a remedy where that person is deemed to have predeceased. So even if it's a child and that person was found to have unduly influenced the person who passed away, and the trust is tossed out, and then it would go by intestacy, which says that kids get a share, the order can be that that person is deemed to have died first, so they get nothing.
Wow. Okay. It's very important to have good planning in place. What do you think most siblings fight about? in trust litigations? What have you seen any patterns?
You know, these are the cases that somebody described to me once, and I've adopted it as the red tricycle case. When we were kids, I wanted a red tricycle and mom and dad got me one. Often in these cases, you can see some long-standing pent-up grievances and hurt and emotion that then comes to the surface, and it expresses itself in litigation. You know, one of the things we all have to remember is, you know, if you're in litigation over a trust or an estate, someone's died. So people are grieving, and sometimes people grieve in a way that causes them to lash out. And you know, so not only are you dealing with the grief of having lost someone, you're also having to deal with litigation at the same time. So it can be a very emotional thing for our clients to have to deal with these kinds of things. And those emotions really can bubble to the surface. You know, another area that we see with some regularity is, you know, one sibling received gifts from mom and dad while they were alive. And you can then see a scenario where mom and dad have then altered their estate plan to favor the other child a bit to balance things out. And if they don't do that, sometimes the sibling that didn't get gifts during their lifetime will say, look, this isn't fair. You know, mom and dad bought you a house when you were 30, and they didn't buy me a house because I had one for myself, and now we're equal beneficiaries. That's just not fair. Not much they can do about it, but you know, anybody can sue for anything, and you know, then we have to defend against that kind of a case.
I can see where some families might be fighting over that. What about a situation where, and these are all interesting to me, and you know, real life things that could happen, where you have a family that there's two blended families. So you have let's just say the guy that died, he had a first wife and 3 kids with that woman, and then he got remarried to a woman he had no kids with, but all of a sudden their estate plan is focused on him and the new wife, and then all of a sudden all the money is going to these kids that, you know, weren't his when he passes, and his other kids don't get anything. Like, do those kids from the first marriage that are actually his bloodline have a reason to say, hey, why are these kids that aren't really his kids necessarily getting everything now?
That is a very common fact pattern.
Like, what recourse do the kids have that from the first marriage that were actually the bloodline, I guess?
Yeah, so it in a lot of ways it depends on the nature of the trust.
Okay.
So if you're talking about a trust, in the event that, I would say that one of the common ways we see that happen is dad is married to mom, mom passes, dad remarries, and then new wife and stepchildren. In the planning, the way to deal with that kind of eventuality is to have, you know, the trusts that separate, right? So you have the survivor's trust and marital trust. And, you know, one component of that is irrevocable on the first spouse to pass. And then dad can't change at least that part.
Right.
But he
Okay.
can retain the ability to change other parts. So, you know, the claims that you see in those scenarios are undue influence, almost exclusively.
Okay.
Where they say that stepmom unduly pressured dad to leave everything to her and her kids.
So all this planning is so important that it's done right. What emotional toll do you think trust disputes take on families? Like, and do you have any thoughts on this, or important steps that they should take if a family is going into litigation?
Yeah, the emotions run high. I mean, being involved in litigation just in general is stressful. It takes a long time. The court process moves pretty slowly. It's expensive. It's scary that, you know, is this going to turn out the way I want it to turn out? And you're dealing with the emotional aspects of grief and the emotional aspects of fighting with family. It's tough. And, you know, the best that, you know, clients can do is, you know, turn it over. to the litigators. And, let us do what we do and get on with your life. If you approach it from a reasonable, rational way and, are open to getting something resolved, you're going to be able to get on with your life a lot sooner with a lot less money going to lawyers.
I think that's good advice. Everyone wants, a lot of times clients really want to be involved in everything, but you should just let the lawyers talk to each other and deal with it. Things move a lot faster and it's a lot less emotional. If someone wanted to protect their family from future trust disputes, what's the most important steps they should take in setting up their trust?
A good planner
Okay.
that is given all the information.
Right.
Not only about the assets, but the family dynamics.
Okay.
If there's a sibling or a child that has issues or spending issues, or there's some reason to do the planning in a way that one person might think is unfair, and tell the planner, look, I'm worried that somebody might litigate over this while I'm gone. And, good planners can figure out ways to disincentivize that and to plan in a way that avoids it as much as possible. Sometimes you just can't. But the stronger the planning that goes into it, and, really the planning, the noodling, the thinking, trying to figure out how to make this so that, people are not so unhappy that they're going to run to court, I think is important. And hats off to all the planners. We don't do it for a reason. And a lot of people talk about the stress in the courtroom. That's my happy place. Trying to figure out all the eventualities of what somebody might sue over on a document that I've prepared. I'd have even less black hair left on my head.
I want to switch to celebrities. So a lot of celebrities are always in the news, and it's always like crazy to me that they never got any planning done, and then they'll pass away and they have these so much money and huge estates, and you got everyone fighting over it. Why do you think that they don't plan, and we see this a lot?
I have no idea. I suppose the only thing I can imagine is they think they're invincible, and
Right.
they're not thinking about that. It comes for all of us. There's that, I'm sure. And maybe folks just get too caught up in their celebrity lifestyle to think about things like planning.
Do you have any particular cases that are kind of famous that you would want to talk about, or interesting? Maybe you weren't the lawyer, but you read about it and thought the litigation was fascinating.
No, I'm reluctant to talk about any of the ones that we've touched. But we've seen some names.
Quite a few, yeah. So let's just say I was in a dispute and I, over my family trust, and I came to you and you got me ready with what we're going to do and what the strategy is. And I want, the trustee removed, and I'm mad at this beneficiary. And you kind of read my case and you think, yeah, you have a case and you're right. We'll take you on as client. How would you prepare me for that? What would make our experience the best, and the process through the court system go the fastest? What would you need me to do as your client?
Be open with me. There is no such thing as a case that doesn't have a single bad fact.
Okay.
They all do. And my job is to understand all of the facts, good, bad, or otherwise, and apply it to the law. And surprises are, it just makes everyone's life more difficult, especially the clients, because then it gets more expensive. We have to pivot at the last minute to try to figure out a way to address some of those things rather than having the time to consider it. And look, if it's a bad enough fact, my job is to tell you that and say, that fact really means that we should look at resolving this rather than litigating it, because this could cause the case to go against you.
That's a good point. Like basically, if I tell you everything, like this is the situation, you might say, if we go to court, it's not going to look good. So let's try to resolve this outside. So that is so important. Yeah. How, if someone had to hire a probate litigator or a trust litigator, how does that work? Do you charge a retainer, and is it by the hour? And would you say, does it depend? How do the fees work? So people can kind of have an understanding of how expensive it is or not that expensive, depending on the case.
Yeah, so in general, it's hourly.
Okay.
And, it's a deposit upfront, and it can be wildly expensive.
Okay.
Litigation is an expensive endeavor, especially if you're dealing with things like capacity issues, where you have to engage experts. You have to engage doctors who will review medical records and make a determination as to their opinion as to whether that person had capacity. It can get shockingly expensive. We do, on occasion, take cases on contingency. If we view a case as having, a good, strong chance of prevailing, and there's sufficient assets, we do that. And often, we will consider taking cases on a deferred hourly arrangement, where, we bill our hourly rates, and, then at the conclusion of the case, win, lose, or draw, then you have to figure out a way to pay us. Hopefully it's a win.
Right.
You're getting some assets, and you can use those assets to pay your fees. But the overwhelming majority of the cases are just straight hourly cases.
Okay. Good to know. Well, is there anything else you'd like to share with us about trust litigation?
Now, the last thing, I guess for me is, in a big part of my career, I represented professional consumers of legal services, big companies and in-house counsel. And, that was rewarding. It was interesting, big cases. These cases, I might be the first lawyer that my client has ever spoken to.
Right.
And certainly the first lawyer that my client is engaged. And the impact and the meaningfulness of what we can get accomplished is huge. It's really rewarding.
It's wonderful. Yeah. It's probably their first experience with a lawyer. I can see that they never really had to deal with anybody, and now someone's passed away and you're like, okay, now I have to get an attorney. You're the first one. You're helping families out, helping people navigate it, and it's great. So thank you for talking to us today.
Oh, you bet. Thank you so much for having me.
We'll have to do it again.
Yeah, that sounds great.
Okay.
If you've enjoyed today's episode, please consider subscribing to the Business Talk podcast and leaving us a review on your favorite podcast platform. Your feedback helps us grow and improve. Thank you for joining us today. This has been another episode of Business Talk with Meghan McNulty.